Hello everyone, I'm Nazarat Fatima. Welcome to LiveLaw. As you're aware, after the hearing in Bilkis Bano's matter started, we covered some of the major arguments in our previous videos. In this video, we'll be covering some more arguments, but to have a better understanding of the case, please visit the videos made on the issue previously. We have gone through a few of the oral arguments made by the parties in the matter. Let's now see what was further argued in the court. To begin with, as far as the question of maintainability is concerned, Senior Advocate Rishi Malhotra, appearing for convict Radhesham Shah, tried to convince the bench to dismiss the PILs right at the outset by arguing that allowing third parties to challenge remission orders in a public interest litigation would set a dangerous precedent by opening a floodgate of litigation. He also pointed out that the public interest litigants had approached the court without going through the remission order, which they in their petition criticized as arbitrary and devoid of any application of mind. Before Bilkis Bano herself approached the top court, a number of petitions had been filed in public interest, challenging the Gujarat government's decision. The list of petitioners include Communist Party of India leader Subhanshini Ali, Professor Rooplekha Verma, journalist Revati Lal, Trinamool Congress MP Mahua Moitra, former IPS officer Miran Chadha Burwankar, and National Federation of Indian Women. However, the government as well as the convicts have challenged the maintainability of the writ petitions filed by politicians, activists, and journalists, saying that they do not have locus standi. While in order to support his contention, Mr. Malhotra relied upon a 1992 judgment in which the Supreme Court had disallowed a petition filed by Akali Dal leader Simranjit Singh Mann, challenging its decision to confirm the death sentence awarded to two assassins of former Army Chief General A.S. Vaidya. Justice Nagaratna said that there is one difference. She said, and I quote, "Whereas in Simranjit Mann there was a challenge to a conviction and a sentence, here the PIL petitioners have challenged the remission order, which is essentially an administrative order. Of course, conviction cannot be challenged by third parties. As the former Chief Justice has rightly said, if a third party challenges a conviction, one party may ask for the death penalty, while another party asks for an acquittal. The whole process will crumble if this were the case." Mr. Malhotra began to say that the facts are different, and Justice Nagaratna stopped him. She said that the facts are vitally different and it's an administrative realm here. Justice Bhuyan added that it's not a criminal matter anymore. He said, and I quote, "The simple question is whether the order of remission is good or bad and whether it is in public interest. This judgment is not applicable." Mr. Malhotra said that there has been an infringement of a fundamental right for the Supreme Court's writ jurisdiction under Article 32 to be invoked. He asked, and I quote, "What fundamental right of the petitioners has been violated? They have not even alleged that their fundamental rights have been violated." In response to this, Justice Nagaratna said, "In public interest litigations, the petitioner's fundamental right is not in question because it has been filed in public interest, not private interest." Later, she explained that both Article 32 and 226 of the Constitution could be pressed into service against an infringement of one or more rights of the petitioners themselves, as well as in public interest where no individual rights of the petitioners have been violated. Meanwhile, the Additional Solicitor General S.V. Raju told the Supreme Court that remission is nothing but reduction of sentence, which does not countenance PILs. In response, Justice Nagaratna said that an order of remission is an administrative order. On the other hand, the Additional Solicitor General said that it may be an administrative order, but the effect of such an administrative order was the reduction of sentence, which stood on a different footing, even if it was by way of an administrative order. Another series of arguments came from Senior Advocate Siddharth Luthra, who said that unnecessary third-party interference would prejudice rights of accused. He told the bench that third parties had no role to play in the prosecution of an offender, nor in any collateral proceeding, such as the grant of remission. He argued that any unnecessary interference by such parties would be prejudicial to the rights of the accused. Moreover, he mentioned the rights of the victims in criminal law. He said that while victims have been given a limited role to play in the prosecution of an accused, there is no space in criminal law for third parties. He also asked the court that despite it being an administrative order, what are the contours of decision making? And later he explained the contours of decision making. Explaining so, he said that after the decision has been taken by the judiciary, which has culminated into finality, and after it culminated into finality, the executive exercised its powers of clemency under CRPC on the basis of parameters laid down by the Supreme Court. Mr. Luthra also told the bench that remission, according to the decisions of the Supreme Court, was a modification in the period of sentence which did not affect the conviction itself, and there are numerous considerations for the grant of remission, such as the ill health of the accused, family considerations, or considerations relating to reformation and rehabilitation. He said to clarify, and I quote, "My point was that there are elements of reformation and rehabilitation in the penal policy in this country, however confused it may be." He made a point about the criminal jurisprudence not envisioning any role of third parties in the prosecution of an offender. He also called it unnecessary interference by third parties, which according to him would prejudice the right of an accused. Later, senior advocate S. Guru Krishna Kumar, appearing for another convict, questioned the maintainability of Bano's petition under Article 32 as well, saying that the appropriate forum to hear the challenge against the remission would be a high court, so that the convicts are not deprived of their right to appeal before a division bench of the High Court as well as the Supreme Court. That would be all about it for now. We hope to bring more arguments in the new videos to keep you updated. Meanwhile, please like and share our videos if you find them useful. Also, subscribe to our channel on YouTube and don't forget to press the bell icon for notifications. Thank you for watching.